repudiation and rescissions. Well, these are commonly confused terms, but they are not synonymous. So to start with rescission. Rescission refers to the act of rescinding or unmaking or undoing a contract. Most specifically, it refers to the right of the parties to a contract to return to the identical state as before they entered into the agreement. In other words, the status quo ante. This can occur by one of the parties declaring rescission of the contract without consent of the other party because of some defect in its formation, for example, misrepresentation, duress, or undue influence. It can also occur by mutual agreement of the parties. For example, if they reach a new agreement or a contract allows rescission by one of the parties based on the occurrence of a certain event or through a court order, an equitable judicial remedy of rescinding a contract in a suit brought by one of the parties. Repudiation, in contrast, refers to the refusal of a party to perform an obligation owed to the other party. It consists of such words or actions by the contracting party that indicate that they are not going to perform their part of the contract in the future. Now, because this occurs prior to the actual breach of the contract, repudiation is often referred to as anticipatory breach. Thank you. A few words about the court system in the United Kingdom. The United Kingdom does not have one single court system. England and Wales are one jurisdiction. Scotland and Northern Ireland each have their own legal systems. While the United Kingdom consists of the three distinct jurisdictions, there are some areas of law in which jurisdiction extends to three or more countries of the United Kingdom. Examples include certain aspects of immigration law and some employment cases. Ex officio is a Latin phrase that literally means from office or by virtue of one's office. This refers to powers that an officer may exercise which are not specifically given to that person but are implied in that office. We talk about ex officio judges or judges who serve in a particular capacity. For instance, on some sort of board or commission because the law requires a certain judge to serve and not because he or she was specifically selected for that position. We also talk about ex officio services, which are services that are deemed to be included in a certain office and that the officer is obliged to perform. We hear this phrase in the sentence, "The treasurer shall serve on the board as a non-voting ex officio member of the board," or "The attorney general enjoys ex officio membership on the sentencing commission," or even Justice Roberts is chancellor of the Smithsonian Institution, one of his ex officio jobs as Chief Justice. In some countries, for example Sweden, ex officio is used to mean on one's own motion. However, this is not the meaning of this Latin phrase when used in English. The Latin phrase that is used to express that concept in English is sua sponte. For instance, we would say the judge dismissed the case sua sponte and not on motion of one of the parties. Thank you. Quorum. Quorate. A quorum is a noun which signifies the number of a body or of any body. It could be a board of directors or a legislative body that is required to be present in order to conduct business and for the meeting to officially begin and make officially recognized decision. Usually, a quorum constitutes a majority of the given body. Some examples of quorum in use include The meeting could not be held because we did not have a quorum, or there were not enough members present to constitute a quorum. There are a number of other usages of quorum. One term, though, that you should make note of is quorate, which is the adjective form of quorum. So quorate is an adjective that describes a meeting that has enough members present to conduct business. For example, the meeting will be quorate if 2/3 of the shareholders are present. The opposite of quorate would be inquorate. Thank you. Board of Directors takeover. A shark repellent, also known as a porcupine provision, is a strategy used by corporations to fend off unwanted or hostile takeovers. There are many examples of this. One example which many have heard is the golden parachute, which is a contract with top executives that makes it extremely expensive to get rid of existing management. Another example is called a defensive merger, in which the target company combines with another organization that would create antitrust or other regulatory problems if the original unwanted proposal were to be consummated. Another example is the staggered board of directors, which is a way to make it more difficult for the corporate raider to install a majority of directors sympathetic to his or her views. And last but not the least is supermajority provisions. These might increase from a simple majority of 2/3 of 3/4. The shareholder vote required to ratify a takeover by an outsider, making it virtually impossible to. Although this concept is well intentioned, many shark repellent measures are not in the best interest of the shareholders, as the actions may damage the company's financial position and interfere with the management's ability to focus on critical business objectives. Again, shark repellents often benefit corporate officers more than the stockholders. Thank you.